I would like to begin with saying that I'm very honored to be a member of the Environmental Research Network and also to be part of its environmental engagements talks. And so I would like to thank you all for your interest in today's talk on wind power from a civil law perspective. The aim of my talk is to address the challenges that Austrian law poses to the purchase, the operation of wind power plants. The central task will be to analyze the challenges posed by property law. This analysis will be performed through the lens of the different actors involved. These actors are the landowner, you can see in green color, the operator in red color, and a manufacturer in light gray. But also creditors, such as banks, play an important role, you can see in yellow color. So we will take the perspective of these actors involved and will try to analyze the challenges that Austrian property law is posing. Doing so, I will adopt a differentiated approach. I will refer to the various types of installations, and I will consider the specific technology in use. So I will apply the necessary distinctions depending on the size and also the specific technology that is used in each wind turbine. I think it is this differentiated approach that is necessary to clarify and understand the challenges Austrian property law is posing. So coming from this understanding, let's take a closer look at the technology in use. And on the present slide, we see the dimensions of a wind turbine of the so-called large wind power. Such a turbine often has a height of 198.5 meters. With this height, it is 60 meters taller than St. Stephen's Cathedral. The tower weighs up to 2,800 tons, and the generator nacelle adds another 650 tons. Tower rings are connected by steel cables. The cost of the construction of the installation of the wind turbine easily account for about 30% of the total cost. These high costs can be explained in light of the installation, in light of its duration. So the crane alone, the crane that later assembles the wind turbine, takes 7 days, and the foundation 23 days, the tower 17 days, and a final assembly another 20 days. So now let's turn to small scale wind turbines. They come in very different models. Some are just clip-on generators, and we can perceive them more like satellite antenna. So you simply clip them on your roof and attach them to the roof, and then they start generating power. So this is one kind or one model of the so-called small-scale wind turbines. A different model would more remind us of a large-scale wind turbine, and it is installed on ground. It is even often installed on a paved area, and therefore we would probably perceive it more like a flagpole or more like a miniature version of a large-scale wind turbine. As I said, taking such a differentiated approach is essential in order to clarify and understand and also overcome the existing legal uncertainties. But which legal uncertainties do exist? In terms of property law, the ownership in cases of the construction on third-party land is an area we should investigate. Wind turbines are often installed on third-party land and therefore on land that is not owned by the operator or the manufacturer. In fact, 80% of large-scale wind turbines are operated on third-party land. In this context, the central question is, who is the owner of a wind turbine after it has been installed, after it has been connected to the ground. Is it the owner of the land, or is it the manufacturer? Is it the manufacturer, as the manufacturer probably has retained property until the last installment has been paid? Or does the landowner automatically own the wind turbine due to its firm connection, firm attachment to the ground? Why is this so important? Let's go through the scenarios. In the first scenario, you can see the change in color. The wind turbine is now colored in green. This stands for the scenario that the landowner is the owner of the wind turbine. And this, as soon as it is erected, as soon as it is installed. This result is contrary to the needs of the stakeholders. On the one hand, it is not the intention of the landowner to own the wind turbine. Correspondingly, the manufacturer wants to hold ownership for as long as possible, and at least for as long as the wind turbine has not been fully paid for, since most wind turbines are usually paid for installments. So let us come to the second scenario. As long as the full price has not been paid, the manufacturer intends to remain ownership. As you can see on the present slide, the wind turbine is now colored in gray. And this stands for the manufacturer's intention of owning the wind turbine also after installation. In most cases, the parties to the contract agree on a retention of title clause. Such a retention of title ensures that ownership does not shift to the operator until the last installment has been paid. Only as soon as the last installment was paid, the operator shall be the owner. As you can see, now that the last installment has been paid, now that the price has been fully paid, the wind turbine is colored in red correspondingly with the operator. Furthermore, the securing of loans needs to be addressed. Therefore, the talk has to answer whether the wind turbine can serve as an independent object to secure a loan. Can it be used as an individual object, and can banks or other creditors hold a security, for example, a Pfandrecht, on the wind turbine itself? Or must the land on which the wind turbine is installed on be encumbered? So as you can see on the present slide, the yellow tag is supposed to symbolize securities on the wind turbine itself, or mortgages on the land. In all these scenarios and viewed from all these perspectives, it is important that the installation of the wind turbine does not interfere with its ownership. In other words, the turbine shall not become a component of the land property. Rather, it should maintain an individual, a separate legal status. But is this a real concern under Austrian law? Answering this question will require a concise presentation of the principles of Austrian property law. In doing so, I will concentrate on the just mentioned aspects. After outlining the basic principles, we will see which concepts and argumentations are advocated in court practice. In a third part of my talk, possible solutions and new approaches shall be introduced and also discussed. Austrian property law predominantly is understood to rest on the principle of superficies solocedit. This understanding is being criticized, but at this point, I would like to not elaborate on this. I will elaborate on this criticism later. The principle of superficies solocedit, which originates from Roman law, means that buildings and other constructions follow the legal fate of the land they are built on. The rationale behind superficies solocedit is that persons buying land shall be protected in their expectations, which objects, which items are part of the acquired property, a part of the acquired land. So according to the principle of superficie sollicedit, the land and the building are understood as one single object, as one single entity. So generally speaking, whoever acquires the land automatically also acquires the building or construction on it. And again, generally speaking, whoever wishes to acquire the building or the construction must acquire the land. Again, the building is colored in green, symbolizing that the building or a construction that falls under this superficie sollicedit principle is denied a separate legal status. Transferred to our question, if superficie sollicedit applies to wind turbines, the wind turbine automatically belongs to the land and therefore is owned by the landowner. As you can see on the present slide, the turbine is colored in green. Neither the manufacturer nor the operator would be the owner. Instead, it would be the landowner and therefore a person who in most cases does not pay for the wind turbine. Now we might think quite simple to solve. The operator should acquire the land, or at least a parcel of it, and then later on have a wind turbine installed on this parcel of land. Again, this approach does not satisfy all needs. As I mentioned before, the manufacturer does not want to give up ownership to the operator, at least not at the time of construction, if the operator has not made full payment yet. Another consequence of superficie sollicedit would be that we would have to mortgage the land, since the turbine has no individual, no separate legal status. So now let us turn to the Austrian Civil Code. Austrian property law is, again, predominantly understood to imply the principle of superficie sollicedit in section 293 and the subsequent, more precisely in section 297. Very briefly, I will now read the text in German and continue with an English translation. Sachen, welche ohne Verletzung ihrer Substanz von einer Stelle zur anderen versetzt werden können, sind beweglich. Im entgegengesetzten Falle sind sie unbeweglich. Sachen, die an sich beweglich sind, werden im rechtlichen Sinne für unbeweglich gehalten, wenn sie, vermöge des Gesetzes oder der Bestimmung des Eigentümers, das Zugehör einer unbeweglichen Sache ausmachen. Perhaps I may point out that this is the original text and wording, so the spelling of some terms should not bother us. Rather, let's continue to an English translation. Objects that can be moved from one place to another without damaging their substance are movable. In the opposite case, they are immovable. Objects that are movable as such So it seems I was muted for a second, and therefore I will just maybe I will start with the English translation. I think that was the point in time when yeah, okay. So thank you, thanks. Objects that can be moved from one place to another without damaging their substance are movable. In the opposite case, they are immovable. Objects that are movable as such are considered immovable in the legal sense if they are part of an immovable object by virtue of the law or the owner's designation. After reading section 293, the follow-up question is, in which cases does the law define what belongs to immovable property? For this, let us read section 297 of the Austrian Civil Code. Again, I start with the German wording and then continue with an English translation. Ebenso gehören zu den unbeweglichen Sachen diejenigen, welche auf Grund und Boden in der Absicht aufgeführt werden, dass sie stets darauf bleiben sollen, als Häuser und andere Gebäude mit dem in senkrechter Linie darüber befindlichen Luftraume. Ferner, nicht nur alles, was erd-, mauer-, niet- und nagelfest ist, als Braupfannen, Branntweinkessel und eingezimmerte Schränke, sondern auch diejenigen Dinge, die zum anhaltenden Gebrauch eines Ganzen bestimmt sind, zum Beispiel Brunneneimer, Seile, Ketten, Löschgeräte und dergleichen. Again, let us read an English translation. In the same way, objects erected on land with the purpose that they shall permanently remain thereon, such as houses and other buildings, together with the airspace vertically above them, belong to movable property. Furthermore, not only everything that is nailed or bolted to the ground as brewing pots, kettles, and carpentered cupboards, but also those objects which are intended for the permanent use, for example, well buckets, ropes, chains, or fire extinguishers. We immediately notice that we are working with provisions dating back to an older time, more precisely with provisions from the original text of the Austrian Civil Code. Now we ask ourselves, does superficie solo cedit apply to wind turbines? First, I would like to present the Austrian court practice. Since Austrian law is no case law system, I will not use the term case law, I will use the term court practice. On January 28, 2020, in reference to section 297, the Supreme Court states, die Regel ist die Eigentümeridentität, Sonderrechtsfähigkeit ist die Ausnahme. So unitary ownership is the standard, a separate legal status, the exception. Admittedly, the statement is rather general, and also so far there were no proceedings dealing with wind turbines before Austrian courts. However, this should not prevent us from considering court practice on section 297 and then very carefully assessing it in light of wind turbines. Again, there is no case law in Austria, but nevertheless, the highest court's rulings on similar constructions should be consulted and taken into account. This might enable us to trace an existing line of reasoning, and it maybe even enables us to build on settled court practice. So let us take a closer look on court practice applying section 297. What is the Austrian Supreme Court's position on the question of which constructions, which objects are affected by superficies solo cedit? Let's start in 1987, the year in which one of the leading cases on section 297 was decided. The Austrian Supreme Court and the prefabricated garage. In its reasoning, the Austrian Supreme Court explicitly confirms that Austrian property law is dominated by superficies solo cedit. In general, a building or construction is a component of the property of the land and is not subject to a separate legal status. Everything built on ground and firmly attached to it, such as houses and other constructions, no matter of what material, and therefore also perimeter walls, wooden fences, permanent flagpoles, are affected by this principle. According to the Supreme Court, the purpose of the construction is irrelevant, and therefore also lookouts, machine sheds, barns, and transformer houses are subject to superficies solo cedit. However, tents, booths, billboards, dismountable barracks, and grandstands are not. According to the court, a prerequisite for applying section 297 is a firm connection to the ground, but not an anchoring or embedding in the ground. The Supreme Court explicitly states that it is irrelevant whether the object can be dismantled in an economically viable manner. Moreover, the Austrian Supreme Court draws on previous cases, on previous court practice on prefabricated houses and prefabricated swimming pools. In these cases, Section 297 was applied despite the fact that they are easily removable. So with this, the court underlines that the question of an economically viable dismantling or removal is not to be asked. According to the court, the decisive factor is the general perception. If the general perception considers an object to be a building or construction, superficies solo cedit is to be applied. However, a further definition of this general perception or guidelines for such an assessment is missing. The court summarizes that according to this understanding, it could not be doubtful that a prefabricated garage is subject to superficies solo cedit. So superficies solo cedit was applied to the prefabricated garage. Maybe allow me to summarize the findings of the Supreme Court in abstract terms. Which criterion is relevant and which is not? The Supreme Court mentions the firm connection to the ground as a relevant factor, but also adds that an anchoring in the ground is not required. In addition, the general perception is decisive, whereby it is again irrelevant what purpose the construction has. It is also relevant whether it can be dismantled in an economically viable manner. If, according to the Supreme Court, permanent flagpoles are considered to be part of the land ownership, I wonder why this should not be the case for wind turbines, especially of the ones of large-scale wind power. But at the same time, the present ruling leaves a certain degree of confusion. The flagpole just mentioned is subject to superficies solo cedit, but a billboard is not. It seems to me that we should keep exploring and gain further insight from some later cases. Let us continue in 1991, the Austrian Supreme Court and the sausage stand. In its reasoning, the court states whether a construction, and in this case, it was a sausage stand on a concrete foundation. So the court states whether a construction falls under superficies solo cedit does not merely depend on whether the object is permanently connected to the ground or if it can be removed without considerable effort. Rather, the general perception is decisive. With this, the Supreme Court, in a way, restates the findings on the prefabricated garage. However, the court adds that the sausage stands, as it sits on a concrete foundation, cannot normally be moved. Furthermore, the court states that its verdict would be different if the sausage stand was on wheels or if it was a tent. So from this case, we can draw probably the following conclusion. According to the court, what stands on a concrete foundation will probably not be moved. So simple as that. Let's go even further and look at the year 2006. The Supreme Court and the outdoor bar. In its reason, the court states that a requirement for a building permit indicates a construction pursuant to Section 297. In this case, the court takes quite an easy way out, but consequently also makes it quite easy for us. Let us continue with more recent cases, the Austrian Supreme Court and the HIREC 2020. I would like to explain just very briefly what a HIREC is. A HIREC is a shelf, a Hochregalanlage, a rack. It is a bolted steel construction and it is used in logistics. So it is used to store goods in a very large storage area. So we can think probably of a shelf with the largest dimensions. In the present case, the dimensions of the high rack was, it weighed 140 tons, was 28 meters long, 6 meters wide, and had a height of 18 meters. All the connections between the foundation and the rack were made with dowels, Dübel. In some places, some joints, but not all of them, but some of them were welded, geschweißt. Again, the question is such a construction, is such a high rack subject to superficie solo cedit? And what is the reasoning of the Austrian Supreme Court? The court states that the decisive factor is the general perception. The question of whether a structure can be dismantled in an economically viable manner, so with little effort and without significant impairment, is generally irrelevant. We find that also the more recent cases maintain, or in the more recent cases, the Supreme Court maintains the view that the general perception is more important than the question of whether it is economically viable to dismantle, to remove the object in question. Furthermore, and quite surprisingly, I have to add, the court adds that whenever the installation or the construction works are carried out in consideration of earthquake safety, Section 297 applies. So this is a very interesting aspect that is not found in previous cases. Now, let us apply these findings to wind turbines and come to an interim conclusion. Large-scale wind turbines, but also most of the small-scale wind turbines, stand on a concrete footing, on a concrete foundation. And they are therefore firmly connected to the ground. And again, an anchoring in the ground is not required. Whether a building permit is required depends on the respective federal law, the federal state law. However, I do not want to address every federal state law, but at least the ones in which the most wind power plants are installed. In Lower Austria, in Burgenland, and also in Upper Austria, power plants require a building permit if they are large-scale wind power plants. As a general rule, this also applies to installations of small-scale wind power. In most cases, the building codes of the federal states nevertheless provide for a building permit. In Upper Austria, however, such a permit is not required if the turbine generates less than 5 kilowatts. The installation of such a turbine would only be subject to a notification requirement. Then finally, we come to our most recently discovered aspect, earthquake safety. All large-scale wind turbines are built in compliance with earthquake safety. Looking at these findings, it seems debatable that courts will apply superficie solo cedit to small-scale wind turbines. I think this is very debatable when it comes to the clip-on models. But courts might apply superficie solo cedit when it comes to large wind scale turbines. As already mentioned, this would mean that the landowner is the owner of the wind turbines once it is installed. As a result, a retention of title securing the manufacturer's interest ceases to have legal effect, and we would have to mortgage the land. However, we do not have to accept this unfortunate conclusion derived from court practice. Austrian law provides 3 instruments which can be used to give buildings, constructions, and also tunnels and autonomous a separate legal status. We can use these instruments to suspend superficies solo ceded and achieve a split ownership. So ownership of the object is split from ownership of the land. These three instruments are the so-called Superedifikat, the so-called Baurecht, and thirdly, the seller ownership. I only touch on seller ownership as it only relates to underground spaces. Renewable power plants and also wind turbines, according to the current state of technology, naturally are above ground, and therefore I will not elaborate on seller ownership. Consequently, we only deal with the question of whether a wind turbine can be erected as a Superedifikat or whether it can be erected on the basis of a Baurecht, as a Baurechtsbauwerk, in fact, a building on the basis of a Baurecht. I would like to begin with the Superedifikat. The Superedifikat is a building or construction that is erected on third-party land with the intention that it should not always stay there and thus preserves its independent legal status. The principle of superficies solo ceded is suspended. The building or constructions as a Superedifikat is considered to be a movable object. It can be owned by a third party, just like a car, for example, and does not automatically become a component of the land property. The positive effect of this is a retention of title is effective even after installation. Pledges can also be granted without encumbering the land. Thus, the Superedifikat can serve as a security on its own. The disadvantage, however, is that fees and taxes apply. Fiscally, for tax reasons, the acquisition of a Superedifikat is treated as an acquisition of land. The tax assessment is based on the value of the building and therefore on the value of the wind turbine. In the case of transfer of ownership, it is also necessary to submit the relevant legal documents to the land registry, for which also fees will be charged. In principle, transparency is not given. However, it can be achieved by a so-called Einreihung, also a form of registry of documents on the land ownership. So consequently, the land register would state that the building standing on the land is a Superedifikat. For this, further costs will be incurred. Now, let us turn to the Baurecht. One translation of the term Baurecht would be building right. However, this translation would be highly misleading. In fact, one could easily think of construction regulations governed by public laws, building codes. And I have to stress the Baurecht we are talking about now is an instrument of a civil law nature. It is not of a public law nature. It is not in a way connected to the building codes. So I will keep using the German term, as an English translation would be too misleading. And then we'll continue by simply explaining what it is and what is the purpose behind it. The Baurecht has a purpose to draw an imaginary surface, an imaginary layer above the ground. This layer can be acquired by the so-called Bauberechtigte, the person entitled to the Baurecht. If the Bauberechtigte now erects a building or a construction on this imaginary layer, you can see the wind turbine on this imaginary layer, the person, the Bauberechtigte, is the owner of the building. So the Bauberechtigte is the owner, not the owner of the actual land. So if we use The Baurecht for our wind turbines, they have a separate legal status. However, in contrast to the superedificat, the building, the wind turbine, is not treated as a movable object. Instead, superficie solo cedit applies, but in favor of the Baurecht, in favor of the Bauberechtigte. So with construction, with installation, the building, the wind turbine, does not become the property of the landowner, but automatically the property of the Bauberechtigte. This means that a retention of title benefiting or securing the manufacturer loses its effect. Generally, the Baurecht requires a registration in the land register, and this also incurs taxes and fees. On a positive note, we achieve a split ownership, but only in relation to the land. It is possible to grant mortgages that only encumber the Baurecht, but not the land. However, they have to be again registered and consequently add to the cost. If we compare the two instruments, we see their advantages and disadvantages very clearly. Both instruments provide a separate legal status and therefore a split ownership. However, the Baurecht impairs a retention of title and thereby prevents it from securing installments. Securities are an option in both cases, but cost intensive, even to different extent. In the case of the Baurecht, a mortgage has to be registered and thus is even more expensive. So how could these challenges be addressed? What approaches can we take? Let us turn to the possible solutions. Let us begin with academic literature. Just last year, a very interesting monograph on options of securing loans with buildings in general was published by Kogler and Meyerhofer, Bauwerke zur Kreditsicherung. This monograph, presenting a highly interesting approach, includes a reform draft. This reform draft refers to buildings in general and would significantly facilitate the securing of loans. Some publications even focus on wind turbines. One position is based on the understanding that it is decisive whether the wind turbine can be removed without effort. According to this position, provided that the turbine can be dismantled in an economically viable manner, it is not affected by superficie solo cedit and can maintain a legal independent status even after installation. This provision implies that the foundation is provided by the landowner. The foundation as a paved area, as a foundation made of concrete, it is in no way economically viable to remove. But as we can see in the present slide, this position argues that the wind turbine itself can be dismantled in an economically viable manner. This view meets all the needs of practice. This view assumes that the wind turbines remains independent and superficie solo cedit does not take effect. Consequently, the ownership of the wind turbine and the ownership of the land remain separate. Consequently, a retention of title by the manufacturer can also continue to be effective. Also, securities only encumber the wind turbine and not the land. With possible solutions, part 2, I would like to add some further ideas and approaches. Again, I would like to stress that in this part, I am presenting possible solutions regarding only wind turbines. So these solutions referring only to wind turbines, they are not referring to buildings in general. One approach could be that a wind turbine can be perceived as a machine. Section 297A secures the legal status of machines in terms of property law. Again, first I read the German text and then continue with an English translation. Werden mit einer unbeweglichen Sache Maschinen in Verbindung gebracht, so gelten sie nicht als Zugehör, wenn mit Zustimmung des Eigentümers der Liegenschaft im öffentlichen Buch angemerkt wird, dass die Maschinen Eigentum eines anderen sind. Die Anmerkung verliert mit Ablauf von 5 Jahren nach der Eintragung ihre Wirkung. If machines are connected to a movable property, they shall not belong if, with the consent of the landowner, it is recorded in the land register that the machines are owned by another party. The entry in the land register shall be invalid after 5 years. To me, it seems quite appropriate to perceive a wind turbine as a machine. In fact, it is a power generator. So section 297A predominantly is understood to not set the legal status of machines in regard to property law, but rather it is understood to ensure transparency in regard to an already existing separate legal status. As I mentioned, a high degree of transparency would be ensured since an entry could be made in the land register. Consequently, a registry fee would have to be paid. However, at the same time, section 297A
Also kannst du mich hören?
is being criticized and raises questions. It is considered questionable whether a machine...
Hallo?
Können Sie bitte aufhören? Können Sie bitte aufhören?
Einen Moment, wo ist der Chat?
So I will continue.
Okay, du musst dich wieder freischalten. Ich habe jetzt alle stumm geschaltet, weil offensichtlich gibt es... Stefanie, du musst dich laut schalten. Es tut mir leid. Okay?
So I hope you can hear me now. Yeah?
Yes.
Okay. So as I mentioned, a high degree of transparency would be ensured since an entry could be made in the land register. Consequently, a registry fee would have to be paid. However, at the same time, this provision is being criticized and raises questions. It is considered questionable whether a machine that is firmly connected to the ground may be considered as an object with a separate legal status. So some scholars argue that in such cases, superficie solo cedit would apply because the machine is firmly connected to the ground. But then also some scholars argue that a machine pursuant to section 297A cannot be affected by superficie solo cedit. So this approach seems to bring up new uncertainties, and consequently, I would like to turn to another aspect from my point of view worth considering. A public interest and the general perception. After all, we are considering the general perception of buyers of land as to what has been sold along with the property, along with the land. After all, this is the rationale behind superficie solo cedit. And even if courts seem to narrow it down to the earlier presented factors, and conclusive definition of this general perception is missing. What we know is that buyers shall be protected in their expectation concerning which items belong to the purchased land and which do not. And this is where I would like to start from an argumentative point of view. Are there constructions that no one can reasonably assume to belong to land property? Are there constructions that no one can reasonably assume to be owned by the landowner. If this is a valid consideration, I think one could speak of a general perception of a split ownership, especially in the case of large-scale wind power plants. I believe that I can support the validity of this approach with a provision from Austrian law. Section 22 of the Starkstromwegegesetz, the High Voltage Power Line Act. Again, first in German and then in English. Elektrische Leitungsanlagen fallen dadurch, dass sie mit einer unbeweglichen Sache in Verbindung gebracht werden, nicht in das Eigentum des Grundstückseigentümers. So power line installations, by virtue of the fact that they are connected to a movable property, do not become the property of the landowner. So Section 22 governs the ownership of electric power line installations and declares explicitly that power poles do not belong to the property of the landowner by virtue of the fact that they are connected to the ground. The aim of this provision is to prevent power poles from being a component of the land ownership. The intention is to maintain their separate legal status. One could also ask, how can one explain this exception from superficie solo cedit? One can consider that some exceptions to superficie solo cedit can be provided on the basis of a public interest and at the same time on the basis of a general perception. So I think it is a general perception that power poles do not belong to the land ownership. I would like to underline that obviously it was considered to be too risky to achieve an exception to superficie solo cedit by means of an interpretation of law. Section 22 pursues the same aim as we are pursuing with regard to wind turbines. If this concept was transferred to wind turbines, a retention of title could continue to apply, and independent securities were an option. And the best thing about it, all this would be free of charge. A direct application of this provision is denied as a wind turbine does not fall under the term electric power line installation. It is not a power line installation, it is in fact a power generator. An analogous application would only be permissible if we argue that the non-regulation of wind turbines in context of property law results in a systematic regulatory inconsistency of Austrian law. If such an inconsistency of Austrian law is present, is given, seems debatable. To be on the safe side, this understanding could be used de lege ferenda in context of wind power. Like power poles, wind turbines could be considered to be obviously not owned by the landowner. A provision modeled after Section 22 could serve a public interest if such a public interest exists. Just as this need was recognized for high voltage power lines, the Austrian legislature could proceed with wind turbines. With this, I would like to thank you for your interest this afternoon